Joining me right now, we have David Peasall, who is the Vice President of Benefits and Human Resources for a company called Frank Crum. David, we've talked a number of times. Good to see you again. So tell us who Frank Crum is. It's a company. What do you do?
Well, we're a 37-year-old company and located in Clearwater, Florida. And we provide administrative services to lots of different industry types of companies. And we process their payroll. We help them with HR administration, benefits administration, workers' comp. We make sure the payroll taxes are paid timely. A lot of different services.
HR these days, I mean, they had them years ago. I'm thinking about 20 or 30 years ago. And I knew they were there, but their role these days is more prominent than ever.
Well, the regulatory environment just continues to grow every year more and more and more. And so really the compliance aspect has become very important.
And because a lot of companies now may have their headquarters in one state and have offices in other states, and then they have to comply with the state laws as well as federal and other laws as well, right?
Right, and so that gets very complicated for business owners who went into business to, restaurant or a pool builder or whatever their nature of their business is. They didn't go into business to worry about HR and benefits compliance.
Yeah, but it's something that they have to be concerned about. We're going to talk about something today, folks, called Ban the Box, which I think is an interesting movement. What exactly is that?
Well, ban the box is a phrase that refers to removing the question on the employment application about criminal activities. And generally that question is, have you been convicted of a crime? There are various ways that's placed on the employment application. It may say misdemeanor or felony, or within the past 7 years, it may say, have words like nolo contender, adjudication withheld, lots of different phrases, but the idea is take that off the employment application and no longer have just the yes, no on that application.
And so just sort of clarify, so there are 30 states that actually have laws that say you can't have that box.
Right, in states, or they have a municipality within that state that has something to say for the private employer that they cannot have that on the employment application. And also it goes on to say that the question needs to be delayed in the interview process. And even in some areas, some regulations say until after a conditional job offer is made.
Now, I understand the box part of it, but then the delayed part. Why would you hire somebody to begin with if you knew something may be amiss at that time?
Well, the idea is that you shouldn't make a blanket decision on that information until you've had time to review the applicant's work history and their education and talk to them about the job and understand their skills and knowledge and make that a decision about whether the criminal activity is important enough to exclude them from the job. Move that later into the
yeah, and
interview.
it's also been called the fair chance, which I think is I mean, that really strikes at what you're trying to accomplish here.
Right, because some companies have historically put that question on the employment application. And because the applicant simply said, yes, I have that, they've ruled them out of the recruitment process, which can be very unfair to many people.
And also, if somebody has served their time, and this kind of gets into restoring felons' voting rights in a way, but if they've done their time to society, then you would say that it would only be fair if they be given a second chance.
Well, and that is one of the, it's called green factors, the nature of the offense, the time that has passed since the offense occurred, and then the job that they're applying for. And so that time is one of those things that employers are expected to take into consideration when evaluating the applicant.
Now let's say that, because I know there are companies, because we're a very large company right here, and I know that large companies that deal with a lot of credit card and very sensitive information have to have special courses. They have to have portions of their buildings blocked off for security reasons, things like that. Can those kind of companies still ask that question, or does it have to come later in the background process?
Unless there's federal or state or some type of regulation that speaks to what can and can't be asked, that should be moved later into the process.
Okay, when you say a background check, what does that mean then? And does the person, now the box is gone, do you have to create some kind of language that says, hey, we're going to hire you based on face value, whatever we see, but we are going to do an extensive background check later on?
Well, I think applicants should be told up front if the employer is serious about the work and education and criminal history, that the employment applications can still say that we're going to do these things, and are you willing to submit to a thorough background check, which includes background and education and criminal history, and make sure the applicant is aware that the employer takes that seriously as it'll be conducted. And So certainly that's an information that should be on there. And then employers can either do those criminal record checks on their own, or they can hire a consumer reporting agency. And once the employer uses a consumer reporting agency or a third party to do those background checks, the employer has to abide by the Fair Credit Reporting Act law.
Okay, so the laws are in place. Generally speaking, do companies get tripped up by this stuff because they just don't know? Or do they get tripped up because they intentionally do it, maybe not out of malice, but thinking, well, I don't want somebody who's got a police record working for us?
Right. There are employers that have perceptions on that really need to, and that's what this movement is about, is making sure the employer really takes into consideration the time of that has been passed, and that the applicants serve their time debt to society, make sure they're evaluating the job that they're applying for and what has happened and the relevancy of that. And so those different things need to be taken into consideration.
Have you, in your experience, and I don't want to ask you to give any company names, but have you worked with companies that you've had to go to them and say, here's what we're suggesting, actually do this?
Yes, so to your earlier question, so a lot of employers are just not aware of these regulations, and they need a resource to highlight the things that they need to be aware of so they don't trip up and do something incorrectly. A lot of employers don't realize if you use another party to do that background check that you have certain regulations or summary of rights that you have to notify the employee of in advance, some documentation that the federal law requires, and a signature from the employee. And then if you're not going to hire them, there are notices that you have to give to that applicant that we're not going to that they're not going to hire them based on what was found in the criminal record.
Does this get to be, even for your company, a little overwhelming when you look at all of the new laws that end up have to do with employment and stuff? You scratch your head and you're going, well, here's another one we have to track.
I would have to say no, it doesn't get overwhelming for us because
what you do.
We're the pros at it, right? There are a lot of laws, and we have a lot of expertise. We have to read a lot of information, pay very close attention to what's going on to the regulatory environment, both at the federal, state, and local levels.
Yeah, and Florida is one of those states where they do not have a ban-the-box bill, although we've talked to some lawmakers that were trying to get it through this session, and not exactly sure how that fared it out. But
yeah. And certainly the suggestion would be it's okay to use the EEOC guidance from 2012,
right.
And it's okay to remove that box unless you have some federal state law that says you have to check that information, that you go ahead and remove that from the employment application, and maybe replace it with a statement that we're going to be checking all of your background, education, work, history, criminal record, and are you willing to submit to that? And that way you don't run into any problems that you still have.
Inevitably, it sounds like common sense, doesn't it, along the way? David, thank you so much. Always good talking to you, sir. Thank you.
Appreciate it.